If we go into a room together and you tell me that you have committed the crime that you're accused of, my advice to you, and the only advice that I can give to you, is that you plead guilty. Now, if you plead guilty, then there's no issue with me representing you because we all understand that you did it. It's just about mitigating the situation or your circumstances. But with cases, and this has happened, where someone says, I did it, but I don't want to go guilty, well, I can't put forward what's called a positive case. So we can go to trial, and if the issue is identification, what I can do is I can ask the witness about the circumstances in which they saw the person. I can, it was dark, it was from a distance, there was bad weather, there was a car parked in obscuring your view, and all of this to essentially test the quality of that person's identification. I can't go any further than that. I can't go further and say, well, he wasn't there, was he? And I can't present an alibi or anything because I know that my client was there. That is the correct identification. So yeah, you run a non-positive case. Normally they're not successful. And I always say this is my job is to help someone present a case. It's not for me to help them build a case. So if I walk in there, I do not go, well, if you say this, that will get you out of here. No. Tell me what happened, and I'll help you prepare a case based on what happened. But yeah, there is a obligation not to mislead the court, and in legal jargon, a court will understand we're not raising a positive case, which I think everyone, wink wink, nudge nudge. Okay, we know even though we weren't there, we know what happened in that conference. It's entirely possible if someone's got mental health issues, drug issues, they might not remember what they were doing that day. So there are other reasons, and the jury will not be told about that because obviously that happened in a conference which is confidential, and you're not allowed to ever talk about that. So rewinding to if someone tells me they done it, I can't present that they didn't do it to the court, but I can't tell anyone what happened in that conference. And there's no obligation. Well, no, there are some obligations involving, I think, terrorism and finance stuff, but generally speaking, there's no obligations for you to ever disclose what your clients discussed with you, including if you have a trial, they're acquitted, and then they tell you they did it.